When a woman gets married, she leaves behind her home, her parents, her family, her friends, and goes to a new house to adopt new people and new culture. That little girl who was reared up with all the love by her parents removes her family name and adopts her husband's family name after marriage. She makes so much sacrifices, but still it is not enough for some people. They want more. They want dowry from girl's family, as if they are doing a favor to girl's family by getting their son married to the girl. And when they don't get what they want from girl's family, they start harassing the woman and goes up to the extent of killing the woman. There have been numerous cases in India where the woman was burnt alive by her husband and in-laws. To prevent such acts, Section 304B was introduced in the Indian Penal Code, which makes such acts punishable. Section 304B basically says that if a wife dies within 7 years of the marriage and such death is caused either due to burns or bodily injury or under abnormal circumstances, and the woman was subjected to cruelty or harassment by the husband or his relatives, then such husband and his relatives will be punishable for causing dowry death. Let's look at the essential conditions to hold a person guilty under Section 304B. The Supreme Court, in case of Pawan Kumar versus State of Haryana, laid down the following essential conditions for this offence. First condition: there should be death of a married woman caused by burns or bodily injury or otherwise than under normal circumstances. Condition number 2: the death of the woman should have occurred within 7 years of her marriage. Condition number 3: the woman should have been subjected to cruelty or harassment either by her husband and or his relatives. Relatives can be the in-laws of the woman or can include anyone else also. Mostly it's blood relations only. Condition number 4: such cruelty or harassment was subjected to the woman for meeting any dowry demand by the husband or his relatives. Condition number 5: the woman should be subjected to cruelty or harassment soon before her death. This is a very essential element under Section 304B, read with Section 113 of the Indian Evidence Act 1872. It is not enough that the harassment or cruelty took place sometime after the marriage. It needs to be proved that harassment or cruelty took place soon before the death of the wife. The logic here is that the courts must be satisfied that the death is caused as a result of or aftermath of such cruelty or harassment. What is soon after death is a question of fact to be decided upon case-to-case basis, and there is no set fixed period which can be called as soon after death. Alright, so if all of these conditions are met, then it becomes certain that the death of the woman occurred due to not meeting the dowry demand. It will be called as dowry death. Now Section 304B has two clauses. The first clause explains what constitutes a dowry death, and the second clause prescribes punishment for such offence. According to first clause, dowry death is a death caused by burns or bodily injury or occurs other than under normal circumstances, and such burns and bodily injury should be a result of cruelty or harassment by the husband or his relatives in connection with any demand for dowry. Clause 2 prescribes minimum punishment of 7 years of imprisonment, which may extend up to life imprisonment also. The offence is cognizable and non-bailable. One important thing to note here is about the presumption. The general rule of law is that a person is innocent unless proven guilty. That means when a person is accused of any crime, the court will treat him innocent unless the prosecution proves such person guilty. The burden of proof is on the prosecution and not on the accused. But for some offences, this rule does not apply, and Section 304B is one such offence. If a woman dies under the circumstances given under Section 304B, then the court will presume the accused to be guilty, unless the accused proves his innocence to the satisfaction of the court. And the reason behind such presumption is that the offense of dowry death is generally committed at home, behind the closed doors, with the support of all family members of the husband. There is no eyewitness, and it is very difficult to prove that the death was caused as a result of cruelty or harassment by the husband or his relatives. This is why law burdens the accused to prove his innocence, so that such offenders do not go scot-free. Now, the wife can die in two ways. Either she can be killed by husband or his relatives, or she can commit suicide because she may not be able to bear the cruelty or harassment by the husband and his relatives. If the wife is killed by the husband or his relatives, the court can impose punishment under section 302, murder, along with punishment under section 304B. Section 304B already provides life imprisonment as the maximum punishment for this offense. And when section 302 is also added, then the court have the power to award death penalty also. Of course, in the rarest of the rare case. If the wife commits suicide, then the courts can impose punishment under section 306, which deals with abatement of suicide, along with section 304B. Also, a person convicted under section 304B may also be charged under section 498 by the courts, but the punishment need not be given separately under each section, as both the offences have the same background, which is cruelty and harassment. What is cruelty? This has been covered under my lecture relating to section 498A. The explanation of section 498A defines cruelty, so you can watch that video or you can read that explanation. I'm not discussing it under this section. What is dowry? Dowry is covered under section 2 of Dowry Prohibition Act. Section 2 says dowry means any property or valuable security given or agreed to be given either directly or indirectly by one party to a marriage to the other party to the marriage, or by the parent of either party to a marriage, or by any other person to either party to the marriage or to any other person, at or before or any time after marriage in connection with marriage of the said parties, but does not include dower or meher in case of persons to whom the Muslim personal law applies. So this definition is self-explanatory. I'll not spend time on this one. Let's now look at the difference between section 304B and 498A. First difference is under section 498A, a woman is only subjected to cruelty and harassment, but the woman remains alive. Under section 304B, a woman is subjected to cruelty and harassment and she dies within 7 years of marriage. That's difference number 1. Difference number 2. Punishment under section 498 is up to 3 years of imprisonment and fine. But under section 304B, the punishment goes from 7 years to life imprisonment. So basically these are the two major differences between section 498A and 304B. I hope section 304B is clear to you all.